everyone. Hope everyone's having a good Friday. Welcome to the call. Let me just switch something here. Okay, there we go. All right, before we get started, see if anybody else jumps on, but does anyone have any specific questions that they have that they've been facing this week or would like to bring up?
I have a question, and I think I know the answer, but so if settlement is, let's say, a week from today, and the seller going out of town, won't be here next week, signs early. Financing and appraisal deadline is next week, just before settlement. And we have yet to sign. I represent the buyer. So if the buyer before their deadline says, oh, I'm having a hard time getting my funds needed to close, can I get an extension? And the seller's either not available or not willing, right?
Mm-hmm.
So we send a conditional cancellation. Is that the best strategy? So either you give us this or we have to cancel? Or is there a better way to go about it nowadays?
Well, the contingent cancellation, I mean, basically you're using that as leverage. It sounds like, so remind me, is there another deadline that hasn't passed yet?
No, F&A is the last one before settlement.
But it hasn't passed?
It has not passed.
Yeah, so you could use a contingent cancellation, which basically says, I'm canceling based on financing appraisal if these terms don't get met, and then you would save your earnest money based off of those. That would probably be your best bet. Yeah.
Does anyone else have any better thoughts or ideas to encourage the seller to give an extension? Send flowers, whiskey, I don't know.
I think the challenge is based on what you said, is if the seller's not accessible, then you're just canceling the contract, is what you're saying.
Yeah.
Sounds like it. Yeah. Which is not the ideal situation. But if worse comes to worse, that's what we have to do in order to be safe, right?
Yeah, if you have something that's going on with your buyer that the terms that the seller has agreed to, they're not, because they've already signed and they left out of town, then obviously they're okay with the terms of the contract currently. If your client is not okay with them, then canceling the contract would be your way of protecting yourself. That's the only thing I can see.
Okay.
See anything different, Russ?
No, I just would say sometimes, and I don't know that you're doing this, but sometimes agents will do that as let's just send over this contingent cancellation saying, if you don't extend this, we're canceling. And then if they don't sign it, then the agent wants to say, well, never mind, we'll still go forward. Like once you send that contingent cancellation, if it doesn't get signed, it's canceled. So, I mean, you could do a reinstatement, but
yeah. But if
yeah.
the seller doesn't want to reinstate it, then your client is out of luck. They cannot get it back in there. So it definitely is a risk. So if there's a reason your client doesn't want to move forward, then you can take that risk. If it's just to delay it, I would be cautious with it because the seller could come back and say no.
Yeah, so let's take that just one step further, if you don't mind. Mm-hmm. So if we do intend to close, but he won't extend, and we're like, we just need a little extra time. I guess I'm worried about the seller has performed, but the buyer hasn't performed, but the buyer wants to perform. They just need more time. That's a sticky situation.
Yeah, because your contract says that they'll close at a certain time, and if not, then your client's going to be in default. So you have one of two choices. One is you go past the deadlines, risk your earnest money, and hope that the seller allows a couple days for you to complete it, or you send over a contingent cancellation, the seller doesn't sign it, it cancels the contract, and you're officially out of the contract. So
okay,
Those are really your only two options that I can see.
Yeah, because the seller can't force the buyer to perform if the buyer doesn't have the down payment.
Right.
Yeah.
Yeah. And from my understanding, I mean, we have three options when a client is in default. One is receiving the earnest money. Two is receiving the earnest money and damages. And then the last one is suing for performance. And I've never seen it where a judge will force a buyer to buy a property, but I have seen it where the judge will force a seller to sell a property.
Yeah.
So those are really your only three options. If default, if your client cannot perform on the settlement deadline, then they're automatically going to be in default. So then the question is going to be, if you want to save that earnest money, you might do the contingent cancellation or try to get a hold of the seller and say, hey, we need a couple extra days or this is not going to work.
Mm-hmm. Okay.
Make sense?
Yep. Thank you so much for the great answers. Appreciate it.
Oh, no problem. All right. Any other questions? Okay, so today we're going to talk about one specific thing, and it has kind of a few different side things that we'll mention with it. But I've talked with the transaction coordinators and Brianna at the front looking over some of the listings. And one of the concerns they've had is about the form, the notice of exclusive listing. So I want to talk a little bit about what that form is, what the requirements are for it, and how to keep ourselves safe. So there's a couple documents I'm going to share, and we're going to talk about these. So just one second, let me. Okay, you should be able to see a couple questions. Russ, can you see those? Just shake your head if you can zoom. Okay, so there's a couple questions. So when you take a listing, you get an exclusive right to sell, and you have to do a listing input for the MLS. All the listings we have to be put on the MLS with our agreement with the MLS, unless we have something signed by the seller that specifically says, I don't want to put it on the MLS. So they have a form for that. So the challenge comes when we take a listing and then the seller says, oh, I don't want to get it on the market. I don't want you marketing it for a couple of weeks. So we got 2 weeks before we actually put it on the MLS, but we have a listing. And a couple of questions that could come up that I wanted to go through. Let's see here. Okay, right here, is there a requirement time frame for entering a listing in the MLS? So the answer to this is the listing must be submitted to the MLS within 5 business days of the effective date of the listing agreement. Now, if everyone is using the Century 21 exclusive right to sell, the effective date is the top date that you put into your contract. Now, does that have to be today's date?
It does not.
Doesn't have to be today's date. It's going to be the effective date of the contract. Now, that's different than the MLS exclusive right to sell. The MLS exclusive right to sell, what date they're signing on is the date that is your effective date. So it's different in our contract. So if you're using the ones you're supposed to, the Century 21 forms, then that date is the effective date of when you want it to start marketing the property and selling it. Otherwise, you still have the exclusive right to sell and everything's the same. We have to put the MLS input in there. In the MLS input, there is, we have to put a listing date as well. That's going to be the effective date as well. And I'll show you why that needs to be. But let's go through these questions real quick. Is there a requirement time frame for entering the listing? It's 5 business days. Okay. The following are exceptions to this: the clear cooperation rule, which we're going to talk about in a second, commercial properties, land and lots, new construction properties, which are under construction, residential properties with 5 or more, and exclusive office listings. Okay, so this right here, this exclusive office listings is what we're talking specifically about today, where it's not being marketed to the public. So then there's 2 differences that we got to look at. One is this clear cooperation, and the other one is having this exclusive listing. So right here, it says we have to have 5 days, but has anyone heard that we have to have it in 24 hours in 1 day? This is where that comes in, the clear cooperation. What is clear
Well,
cooperation?
if you start marketing the property, then you
Yep.
have to do it on the MLS within 1 day.
Right. That's exactly what the difference is. So if I take an exclusive right to sell and have an effective date, I've got 5 days to get it on the MLS before I start getting fined. If I start marketing that property, and marketing it means I get to put a for sale sign up, or websites or any of this stuff here, then I have exactly 1 day to get it back on the market. The MLS states that we need to put this in 1 business day from the first public marketing of the property. So if that's on there, you've got to make sure that you're putting it in 1 day. Now, it's not 5 days plus the 1 day. So it's important to note right here, it says important to note that this rule trumps the 5-day listing entry rule. So if you start marketing the property, you instantly got 1 day to put it on the market, or you'll start getting fined. Last question on this one is, what if I have a valid listing agreement with property is not ready to be shown or marketed? Okay, there's 2 ways that we can handle this, and we're going to go specifically into the exclusion side of it, but I wanted to touch on the other side too, because in my opinion, it's actually easier to do it this first way. It says if the listing is not ready to be fully marketed or shown, you should still submit the MLS listing to the MLS within 5 business days. However, after entering the listing information, you can place the listing in active no-show. This is the key. This is the question I get a lot about active no-show. Active no-show status, days on market are not accumulated. Photos are not required. Listing will not be visible to the Utah real estate. So if you put it on the MLS and you instantly turn it to active no-show, it's not being syndicated to any other sources. So you're not going to get the I don't have the pictures up there yet, and so I don't want it to be out there. This is a big thing with active no-shows. It's not going to be marketed out there. The other thing is we're always concerned about the days on market. We don't want to put our listing on, not be able to show it for 5 days, and then we put it on, they finally get to look at it, and it says it's been on the market for 5 days, which kind of hurt us more a couple of years ago, but it's still not really good. I mean, you can think about anytime you show a listing that's been on the market for longer than 30 days, we're thinking something must be wrong with the property, or we're going to offer less anyway. So the other option is so that's one option. So one option, you get all the papers signed, you put it on the MLS, you turn it to active no-show, doesn't change anything with the days on market. The alternative option would be to file an MLS listing exclusion form, however, pursuant to the instructions acknowledging that the seller and the listing broker makes the filing the MLS exclusion form on the property that is excluded from the MLS cannot be publicly marketed in any way. So if you're going to put this notice of exclusive listing, you still can't put up your sign. You can't market this at all. So that's the difference with this. But once you put it on the MLS, then the days on market start counting then. Okay, so those are the 3 questions. I'm going to show you more in depth on the exclusive, the exclusive right to sell or notice of exclusive listing. Any questions on the clear cooperation side of it, or the active no-show? So we're going to talk about the other one more in depth, but do you have any questions about that one before we move on to there? Okay, so let me bring up this one. Okay, I'm going to share the rule first, and then I'll share the document with you. So right here is in our Utah real estate rules and regulations. This is the section that talks about exclusive office listings. Just going to read it for you. For any exclusive office listing, the seller, listing agent, subscriber, and listing broker must sign and submit URE's MLS listing exclusion form to UREs confirming the seller's decision to not publicly market the property, to not submit the listing to the MLS, and to not have the listing included in the MLS compilation. Exclusive office listings may only be marketed directly between the listing broker and the listing broker's agent subscribers. All MLS listing exclusion forms must be submitted to the URE within 5 business days after the applicable listing agreement has been signed by the seller. The MLS listing exclusion form is available within the and downloaded to subscribers. So let me show you that real quick, because this is where we're seeing some errors that come up. Let's see here. There it is. Okay, you should see the MLS in listing exclusion form. This is in .loop and it's also in the MLS. So this is where you're going to get it. So you're going to fill it out just like normal. Property address, listing contract date. That's the effective date that you signed your contract. Listing expiration date, listing agent's name, listing office. Then you're going to check one of these boxes down here. Seller instructs listing agent. Whoops. Let's take that off. Instructs listing agent to do one of the following. So the first one is do not submit the property to the MLS until a specific date. So if your seller says, hey, I don't want to put it on until let's put it on October 2nd on the Monday right after we get into the new month, or I'm going to be out of town until this date. This is when I want to put it on there. Then you can put that date there. If you don't know the specific date, then what I suggest you doing is the second one that says do not submit property to MLS until listing is publicly marketed. So that gives you the opportunity that once you're ready to go, you can start marketing the property and then you're going to submit it to the MLS. The last one is do not submit the property to the MLS while the listing agreement for the property is in effect. So this is basically if the seller is saying, I don't want you submitting to the MLS at all, this is where it is. So they want to make sure that everyone who's doing this understands this part right up here. By submitting this form, your property will not be publicly marketed or listed on the MLS and exposure to 16,000 plus Utah real estate agents and their clients. Basically, what they don't want is someone to come back and say, well, you didn't put it on the MLS, and that means I lost more money than I could have got. And what happens is then we get ourselves in trouble by not putting it on the MLS. So you're going to have them sign it, seller's signature, and then you're going to sign this, or Russ and I can sign it. This is the part right here that I want you to look at. Very bottom of this form, it says this form must be submitted to the MLS within 5 business days after the listing agreement has been signed by the seller. Okay, so once I've taken a listing, if I've decided, I've got 2 choices, well, really 3 choices. 1, put it on the MLS within 5 days. Okay, 2, put it on the MLS within 1 day of actively marketing the property. Okay, I can put it on the MLS and then put it active no-show. That means nobody's going to look at it and the days on market aren't going to go. Or the third option, which is this one, which is basically saying I'm not going to put it on the MLS yet and I can't market it at all. So you have to send that into the MLS. And the reason that we have a problem with it is, I'm going to share with you this. If you go into
Jason, real
Yes.
quick, on if you do the exclusion form, though, the days on market will accumulate though, right?
no, they actually won't. I talked to the MLS this morning
Okay.
about that.
Okay, good. to know.
It doesn't accumulate. It accumulates starting the day that you put it on the MLS. So I was under that same assumption, Russ, but I did call him this morning and talk to him specifically about that because I was under the assumption the other way. So so if you go into .loop, okay, if this this is our listing input form. This date right here, this listing date, what date should go in there?
I say the date you intend to put it on the MLS.
Okay. Anybody else? Okay, so
Well, technically, it has to be the date that, they signed the listing agreement, doesn't it?
yeah, so we could possibly have 3 different dates, and the one that actually should be in here is the effective date of the listing. Okay, this is where the confusion, where before when you put the date there, the assumption was, oh, if I don't put it on the MLS for 2 weeks, then when it hits the MLS, I'm gonna have 2 weeks of days on market. They informed me today that as soon as I put it on the MLS, that's day 1. So in this one, if I do it the way, Rebecca, you're saying I would put the date that I signed it. If I have a different effective date on my exclusive right to sell than the day they signed it, then those dates are going to be off. So I'd rather you put the effective date of your listing agreement there and then the expiration date it. If you put if you put the date that you want to put it on the MLS, then that's going to be flagged in our system. And it's going to come back as saying your exclusive right to sell and your MLS input form are, they don't match. Okay, so you want to do the effective right to sell. But here's the key though. If I submit this to the MLS and I have not done this form, okay, let's go back to this form. If I go back, if I submit to the MLS and I put 2 weeks ago on that listing date, and I didn't do this part right down here at the bottom, okay, where it says this form must be submitted within 5 days to the MLS. If I don't do that, it's going to give me an error, which is why people are going in and changing their listing input form to reflect the date that they put it on the MLS. And so it's making an error, and then we have to go back in and do an addendum to your exclusive right to sell, because that's why it's erroring now. So this has to be submitted so you don't get in trouble with it.
So Jason, I think one of the things that is, I guess sometimes difficult is, unless that day matches, like if you want to put if you want to put all the information into the MLS, that date has to be either today's date or, going forward, or you can't put it in if it's not the date, unless you use the exclusive right to, unless you do that, putting it on hold, you put it on the MLS and then put it active no show. You can't really put everything in there into the MLS until that date matches, like today's date. Or if it's not till the future, you can't really go in and do all those features and do all of that information.
Yeah, you can't do the future, but you can do the past as long as you have this form sent to the MLS.
Correct.
Okay, so Jason, there's a lot here, and I'm not sure if I'm understanding everything. Can I just say what I'm hearing, and you can give me some corrections? So, are you saying that it's the listing date is the date that it's ratified by the seller, even if there's verbiage in that listing that says it will be marketed and go on the MLS on another date or 2 other dates? Because legally, I would think that it's the date that a seller signed the listing, no matter what alternate information's in that listing agreement. So that's the first question. And then what you're saying is, if there's a delay on, if you market right after you listed it and it's not on the MLS, you got to get it on within 24 hours. The other date is, it's normally 5 days after you get the listing to get it on the MLS. And so I think those are the 3 dates you're talking about. And I just have a question, if this is what you're trying to say. Am I
Yeah,
understanding it right?
well, so yes, but we're intermixing a couple different topics and a couple different things we're doing. So let's take a step back and just talk about the exclusive right to sell. Okay, so in the exclusive right to sell, there's a date at the very top that's called the effective date. Okay, the question I would have is, can the effective date be a different date than today? If my clients are signing today, they're going to sign the exclusive right to sell. Can the effective
And that
date?
is yes.
Yeah.
I don't see how that's possible because it's not ratified. You don't have any authority.
So that's the difference between the Century 21 exclusive right to sell and the MLS exclusive right to sell. The MLS doesn't have a section in there that talks about what the difference between today's signing date and what the effective date is. In the Century 21 form, you're saying it's not ratified, meaning it's not valid, but once you've signed, it's not going to go into effect, but there is a clause that we have put in there that says, if you sign anything from now until our effective date, our listing will take precedence. So we have that specifically written into our contracts so that it fixes that problem.
Because of the issue that if someone is walking and talking as if they've hired you, that will hold up in court.
Yes. So
Okay.
so let's say that I sign it today with you, and then I put, it's not going to be effective until, I'm not doing anything with it until next week.
You get back from Europe and that's in 2 weeks or something.
Yeah. Okay, so I'm going to get back. So I'm going to put my effective date in 2 weeks. Okay, the concern is what happens next week when your client is at a dinner party and they run into a real estate agent and the real estate agent says, well, have you listed your home yet? Oh, it goes on the market the 1st of October. Oh, well, then let's sign a contract. So because our effective date is the 1st of October, the concern is, well, where's my protection? And in our exclusive right to sell, I don't actually have that pulled up or I'd show you, but in our exclusive right to sell, it specifically talks about that scenario where even though our effective date of our contract doesn't start until this date, because you've signed it on today's date, between now and the time it's effective, that contract is still
Yeah, that's valid. So my issue is you're agreeing with me that it was signed.
Mhm.
Okay. So you did say that if they're doing things as if they have agreed, even if it's not signed, you mentioned that, but I think you answered my question that I think we just all make life easier if we just get it signed and don't do all this creative stuff.
Well,
Right?
and the reason that, I see this happen a lot. I mean, obviously, I think the best way to do it is get it signed, get it on the MLS, get it sold and get paid. That's the best way to do it. But the reality is things come up. Sellers have different reasoning for, not wanting it on the market right away. And we've got to work with some of those reasons. And so if you use the exclusive right to sell, well, then the first thing you got to do is you got to sign one of these notice of exclusive listings, or you've got to put it on as active no-show. With our exclusive right to sell, we have a third option, which is we don't have to do any of those things until our effective date. And if our effective date is out a week or two, then we don't need to do any of these things until the effective date. So those are the two differences. Does that make sense?
Jason,
Right,
can I make
and-
a comment here?
Yeah, sure.
Just to maybe that would kind of help Rebecca. I had a listing just a little while back ago that they were not ready. They had some things that they needed to do. They didn't exactly even know when it was going to be ready, but they thought, they'd be ready by a certain date. But instead of not signing a contract, we signed the contract with the date we were there for the listing, but we put that effective date out by 2 weeks so that they could get their home ready. But I still had a signed contract. I wasn't, waiting for them, and maybe something happened in between then. And I thought it was very effective to be able to have that signed contract agreement between us, but not have the effective date begin for a while.
Yeah, that helps. And in that scenario or scenarios like it, you hand the listing in with that other form. So that's the other thing I forgot to say, but I'm aware of it. So
Yeah. So it's a different option, but the challenge that we're seeing is instead of using the right forms, we're putting the wrong dates on like either the MLS input, or we're creating different things in our listing that we ultimately have to go back and try to fix so that you don't get fined. And that was actually the last thing I wanted to show you guys, because I think this is interesting. I don't know if you guys are aware of this, but let me show you this fine chart. Let's see. Okay, so here is Utah real estate, and I always joke that I think there's a department, I don't know for sure, but it seems like there's a designated department at the Utah real estate that's their whole job is to go out and find people and get money from them. So there is a 5-tier system of fines that when you mess up, this is where it starts at. So if you're in tier one violation, if not corrected within 3 days, it's a $20 fine per business day. And these are those items. They're smaller items. The ones we're talking about here, exclusive office listing requirements. So if you don't get that office listing put in, that is part of tier 2, which if you can see right here, that's a $100 fine just for having that mistake. It could also run into a tier 3 fine, which is late entry of your listing, which is a $250 fine. And then the last one that I see here is if you break the clear cooperation rule, that's a $500 fine for that rule. So they're out there trying to find these problems, and we're just wanting to make sure that when you are filling out your paperwork, you're putting the right things in there. So your MLS input date and your exclusive right to sell date, those need to be the same dates in order for you to do that. Any questions on those? I know we always love to, it does say on the fines though, if you do get fined, you can dispute it. You have up to 30 days to dispute it, but they do try to fine you, and then it increases by every time. If you do it more than once, it will double, then double, and then double. So it goes from 250 to 500 to 1,000 to 2,000. So try not to do those violations. So really, let me just recap real quick. I take a listing. I have 3 options. I can put it on the MLS and put it as active no-show. So I'm not going to market the property, and the days on market aren't going to go. I can put it on the, take the listing and sign a non-exclusive listing. So I don't have to do anything with it until we're ready to put it on the market. But I do have to turn that form into the MLS within 5 days, or I can just put it on as active and get it sold. Those are our 3 options, but just make sure that you're doing one of those. And if you decide to do the notice of exclusive, the one that we're missing is to actually send it into the MLS. It's your responsibility to forward that onto the MLS. Unless you're using a transaction coordinator, then they will do it for you. So, okay, any questions? Hopefully that was helpful for you. Okay, have a great weekend. Enjoy the cooler weather.
Thanks
thank
so
you
much.
so much. Great job. Thank you.
Oh.